The member from Thornhill.
Thank you very much. I'll be sharing my time with my colleague, the member for Dufferin-Caledon, who's been a fantastic advocate for children and youth. I know she's going to continue to be dedicated and involved, even though she recently passed the torch to me, Mr. Speaker. I'm the newly minted critic for children, youth and families for the PC caucus. It's been over 30 years since this piece of legislation was overhauled, and of course we're speaking today on Bill 89, Supporting Children, Youth and Families Act 2016, for anybody who just turned on the channel at home. And it's really time for an update, I think we all agree. And while we might differ on some small parts or wonder how best to implement or fund the system, we're all in agreement that we want the province of Ontario to promote the protection, best interests and well-being of all our children. For years, many organizations and stakeholders have pointed to ongoing issues with the child welfare system. The Auditor General has laid out problems with the ministry's accountability in 3 separate audits in 2003, 2008, and 2016. For too long, there have been serious deficiencies in the system, which have let our most vulnerable slip through the cracks and, in some cases, even death. 2 that I'm going to mention because I really think that their life was not in vain, even though it was cut so short. And Caitlin Sampson, who was murdered by 2 caregivers in their Parkdale apartment on August 3, 2008. And when paramedics found her lifeless body covered in 70 gruesome wounds, an autopsy showed she had died of septic shock stemming from her injuries. So I think that her name is a name that all of us will carry for the rest of our lives. And I think that with her memory, this new bill was drafted. As well, we remember Jeffrey Baldwin, whose death, also from septic shock after years of mistreatment by his grandparents, led to significant changes in policy by children's aid societies in the granting of custody to relatives. Many advocates for children's rights believe that our services need to be more child-centred by focusing on the rights and wishes of the child. And I think that it's difficult, Mr. Speaker, sometimes to engage with a child who's been traumatized, but I think that we can and we should do more to speak to the children themselves, and not just to find out their wishes, but I don't think that you get a clear picture of the situation a child is in without even trying to talk to the child. Children should be encouraged to express their views freely and safely, and their views should be given due weight in accordance with their age and maturity. Children should be consulted on the nature of services they are receiving and advised on decisions made and informed of these rights. The bill also attempts to focus on the importance of a child or youth's identity, example, culture, race, sexual orientation, gender expression, etc., and how and what services are provided. Many community organizations are raising concerns by what this entails exactly and have concerns. I am concerned myself that this Liberal government hasn't done enough to address those communities' concerns, and I would like to see a lot of consultation, and I'm hoping to see people make it down to committee, and they can email as well. They don't have to make it down here in person. People can even phone in. I'm hoping that before we go to committee, we meet with our community members in our ridings and get their viewpoints. We all know that this new legislation is attempting to better match our human rights code. We hear oftentimes about human rights, and it's important that our child protection workers are encouraged to have conversations with the children so that they're better able to successfully place them in our communities. Youth themselves who were in care were engaged in developing this piece of legislation to better focus on the rights of the child. Child protection workers should have conversations, and I think that it's very important to have those tough conversations when it's age appropriate, in the right circumstances, with the children about their feelings and their background and their interests. I want to mention that there's a big problem in our province with mental health wait lists. And it wasn't something when I was a child that you heard so much talk about the mental health of children and youth, but I think we're understanding now that we need to intervene at much younger ages and deal with things, that it's not just a phase that a child is going through. We need more pediatric psychiatrists, and we need more beds in units for children and adolescents who are in mental health crisis. We hear that there's some change in the language in the bill. Crown ward is being changed to child in extended society care. They're removing the term runaway. and the term abandoned is being replaced with parent not available. And, you know, words are just words sometimes, but they can be powerful, Mr. Speaker, in changing the whole dynamic of what we're referring to. We're not referring to a child as wanted or not wanted, or I'm reminded of the Paradise series that's on, I think it's on Netflix now, where they refer to foundlings and wanted children versus not wanted children. And it's just horrific when you realize the language that was used not that many decades ago in terms of children in our communities who don't have proper homes. Lauren Israel is not the only family law lawyer in Ontario that is worried that there's not enough money available to address the long waiting list for services for children and youth counselling. She specifically mentioned, you know, the lack of psychiatric beds. She'd like to see more parenting courses that are culturally and language appropriate, especially for parents in custody or on bail. And there's still a lot of families, she reminded us, who lack proper housing. There's a lack of specialized lawyers in legal aid and a lack of family courtrooms. After all, if you can't get a courtroom, timelines are useless. And I want to say that again, Mr. Speaker. If there's long waiting lists and you can't get a courtroom, we can pass whatever legislation we want. We can say that a child has to see a pediatric psychiatrist within a month if they're exhibiting signs of mental health distress. But if there are no spots available, are we really doing what's in the best interest of the child? So we always talk about the weak link in a
Thank you. Continue.
Thank you very much, Mr. Speaker. I have to say, after 3 years of talking in the legislature, I don't notice it anymore. It's amazing. But we should all be respectful when there are new members in the House to remind ourselves that it's tough when you first get here, those first few months, to be able to talk over, well, heckling for sure, that's tough, but background conversations as well. I guess we all learn to go into a zone. So again, Lauren Israel, the family law lawyer that I was, talking to, wanted us to know that she finds our courts are very sensitive to kids. You know, I asked her if she had any concerns, and she said, you know what, really, she finds that the judges speak to the children a lot, that they're very sensitive. They consider things the child's age and maturity and the level of understanding, and are also very cognizant of the risk in children's young lives, what the potential risk is based on their decisions. And she also feels that our social workers are extremely conscientious and really do visit the kids appropriately. She checks up on it in the files, and she feels quite confident that for the most part, obviously sometimes they're social workers, we all know they have families as well and medical concerns, and there could be times when there's a bit of a struggle in a specific agency, but she feels that the agencies certainly that she is working with are doing a great job. There's part of the bill that focuses a little bit on extra-provincial child protection orders, and this is an inter-provincial project sometimes with children. They could have one parent in one province, a parent in another province, or parents have moved and the teenager is acting out because they don't want to move. So we have to be able to coordinate with the other province. So I would ask again the people who are drafting the legislation and looking at amendments that they're considering what's going on in other jurisdictions so that we're more in line, so that we're not having kids on long waiting lists or problems in understanding. Even language has to be well thought out and in line with other provinces. My next topic is youth justice, and there are reasons why youth are not incarcerated with adults, and I think that we all agree with that. Whenever, though, we make legislation, there's always seems to be unintended consequences. So I would ask that we go through every piece of this legislation and we take the time to think of possible unintended consequences. We wouldn't want to see, say, a gang where, I think that it's been discussed in the past in our media that a gang will recruit somebody under the age of 18 to have them do whatever serious crime that they're looking into participating on, and because they know that that youth will not be charged the same way they would if they were 18. I think our courts have kind of smartened up to that and take that into consideration, and we do see sometimes children under the age of 18 being treated more like adults. And I think, again, it talks to our justice system and the judges' understanding and lawyers' understanding of the ins and outs of what's going on. Society expects us all to help the youth develop their skills they need to reach their potential. We don't want to incarcerate youth and just have them get out and go back and look for whatever gang they were involved in or whatever activity they were involved in that put them in there in the first place, and we don't want to have that revolving door in our youth centres. So we have to make every effort to ensure that they're getting the support. The emotional support is very important, and as well as some kind of training. I would hope that in our youth centres, I have never been to any of them, and I'm hoping I have that on my list of things that in my new portfolio that I would like to do and have a much better understanding of. But the other flip side is, if you're working with difficult youth, is we have to keep our employees safe. And I think that I would like to take a second to offer condolences to the family members of a youth and a worker who died just this past week in Kawartha Lakes in a fire that seems to have been deliberately set by one of the youth in the group home. And you know, these tragedies can happen in kids who aren't in care, that they have a fight with parents, or things can go from bad to worse in a family home. But we certainly have to provide the protection for the workers in the home, and I'm sure that there's going to be a lot of investigation, and hopefully maybe from that investigation there may be even amendments put forward for this piece of legislation based on the tragedy that just occurred last week. When children are being incarcerated or acting out, they often have to use some kind of mechanical restraints to protect not just the workers, but the children, the youth. I don't want to call them children, the youth themselves. And it should never be used as a means of punishment. It should really be used, we understand, for protection, and we all agree, I'm certain, with that. And there are outlined in this piece of legislation the exact circumstances when mechanical restraint equipment can be used, and they are, you know, might change depending on the settings and the circumstances, and we all understand that. And we can't sort of put ages, because we all understand that you can have a 12-year-old that is stronger and bigger than the workers there, while a 16-year-old might not be. They are seeking to replace the word secure isolation with secure de-escalation. So we've been talking a lot in the legislature about people being isolated for very long times, months and even years, in our adult centres, detention, jails, but we certainly wouldn't want to be isolating youth. The whole point is to rehabilitate, and how can you possibly do that if they're locked in a room by themselves? Another family lawyer that I spoke to is Colin Tobias, and his wife is also a lawyer, and they wanted to express that they're very happy to see that we're expanding the age of protection to include up to the age of 18. But they want to remind the legislature, Mr. Speaker, that kids vote with their feet. So we can implement whatever rules we want, but we really, especially with youth, we really have to have them agree to whatever the plan is, and to sit down and to have that plan, not just tell them today we're doing this and tomorrow you're going there and the next day we're doing this. I know from my own experience with my teenagers, nobody likes surprises. We don't like surprises. We're not that happy when we show up to debate one bill and we're being told by the government, no, we've put that aside, we're going to be debating another bill today. You feel a little bit flustered. You feel a little bit anxious if you're not prepared, but it's more than that, Mr. Speaker. You feel disrespected sometimes. So it's very important with youth, with teenagers, to ensure that they feel part of that dialogue and part of that discussion, and that they don't feel disrespected. I think that a lot of times we forget our children are growing up, and it's tough for a parent who's used to, I see the pages are all agreeing with me, it's tough for the parents to realize that their young child is now moving into adulthood and has opinions and interests of their own. Colin Tobias, the lawyer, told me of a recent case of a kid who turned 16 on a Saturday, and they couldn't convince him to go into care. They wanted him to go into care before he turned 16 because they knew then they wouldn't be able to get him into care. And they were able to have that discussion and convince him to go into care for one day on the Friday, just for one day. And they said, and you could get to leave on the Saturday, so it's just for one day to go into foster care, so that it will be an option for you for the next 2 years, that if you do decide you wanted to go into care, that option would be available. And they did convince him to do that, and he went into care for the one day, and I guess now he's on the roster, and I think that's why we're seeing the consequences of those situations and the frustration of social workers. It's not just about children turning 16 and needing to go into care. They may have needed to go into care when they were 15 and refused. And now when they're 16 and a half, they decide they do want to go into care and they can't because they hadn't been placed before. What we hear over and over again from speaking to people who work with youth in the communities is that education is the way out. And I think that that's the answer for every community. That's the challenge. The challenge is, as sort of people who've experienced life, we understand that education is vital to reaching your full potential, but it's very hard sometimes to convince teenagers of that. And so the suggestion was made to me that they would like to see the high school credit system, more of a province-wide high school credit system, and more of a seamless system, sort of a virtual, I sort of marked this down, it's my words, a virtual schooling with some kind of virtual school board. And we see that sometimes for homeschooling, that there is sort of a province-wide supervision of children who are homeschooled. So why can't we do that for children who are struggling or in care, that they're not having to switch school boards necessarily if they're being moved around a lot or if it's a very complicated situation, that maybe there's more of a province-wide school board that can supervise their education and move them more seamlessly if they do half a year at one school board and half a year at the other school board, that they're not losing that course credit, because really they completed the course, except they did it at 2 different school boards, and it's not so easy. Sometimes it can be transferable. It's not so easy to transfer it. It's a lot of work, I imagine, for our caseworkers. When we need them out there doing other work, we have them dealing with the school board. So I'm just throwing that out as something that we can have a discussion at a later date. I spoke to a lawyer who works with children and a third lawyer who mentioned that large foster homes are often in Peel and Durham, and that kids are often moved between boards suddenly. And the specific problem is the special needs services. That's the big challenge, is the special needs services in our kids. And she said that there's long waits for specialized service classrooms, that about 80% of kids involved in the court system and about 2/3 of those have educational gaps and need specialized classes. The crisis is, she feels, the elderly cohort of foster parents that are retiring, and she'd like to see more wiggle room for who can foster a child. I don't know exactly what her, her experiences are, but my understanding is that some foster parents feel unable to have more than one child in their home, and they're pressured into taking more children than they want to handle. There's oftentimes parents have sort of complicated schedules that maybe they need to support. Perhaps there's 2 homes that want to help out half a year and half a year. I'm not saying that's ideal, but I think that if we have such long waits for foster parenting, that we really need to do more to get in those communities and ask people, what would it take for you to be a foster parent? A lot of times people have misconceptions about what's involved. They think they can never go on vacation, or what happens if they get sick suddenly, are they stuck? That they don't understand that there is a process to have the children be moved temporarily if there's 1 or 2 vacations a year, obviously not somebody who travels a lot. And I just wanted to talk about the Child Protection Information Network, CPIN, which is being implemented. In some agencies, it's already fully implemented, and it's been a big challenge. We've heard a lot of discussion in the legislature about other software, SAMs, and it doesn't seem that we're necessarily ensuring that the bugs are worked out, and I don't know exactly who just makes the decisions about information technology in the legislature, but we certainly saw from eHealth that the taxpayers' money was not spent wisely in terms of computers and software, and we didn't really accomplish anything with the $1 billion on eHealth. And I'm sure that CPIN, we're making progress, but it seems like there's a lot of flags that have gone up from the agencies, and they have to go to the centralized ministry. They understand why, because they want the problems to be fixed so that in the other agencies, the problems are fixed as well. If one agency fixes their IT problems, the other agencies might not know about it if it's not going to a centralized place. But then on the other hand, if it's going to a centralized place, there are complications. So CPIN, we know, is trying to streamline all the agencies across the province so that there's better tracking of the children and who is taking care of the children. I think that if we have a better system in place, it would be of huge benefit to the challenges we have in our community with human trafficking in the sex industry of young youth. So we have to do everything we can to ensure that the process goes faster and more effectively. We are hearing a lot of concerns about CAS amalgamations, and this new piece of legislation will give a lot of power to the ministry, the minister, in terms of forcing some amalgamations and what that would mean in our communities. Again, I would like decisions to be made. Obviously, there's efficiencies and monetary concerns, specifically now that we're increasing the age of care to 18. There's a lot of monetary concerns. But I think that, again, we have to be making these decisions in the best interest of the children, the youth, the care workers, the foster parents. Everybody really needs to be considered when we're making these types of decisions. We certainly don't want to fix one problem, Mr. Speaker, and see that we've created way more. I want to mention access centres for children that I didn't specifically see anything addressed in the legislation about access centres, but I understand that they really don't have much space available evenings and weekends. And these are centres, for people aren't aware, where parents can go and have visitation with their children if they have visitation rights, but it has to be supervised. So they have to have an appointment. They don't just drop in. Obviously, their child has to be brought there. And obviously, it's challenging for a foster home to have to bring a child in an evening or a weekend. But the child's in school during the week, the parents have work possibly during the week. I would like to see more of a community discussion on possible, maybe creative solutions to access centres. Perhaps the social workers could visit with more of a, we have an eye centre up north where they go with a clinic. It's mobile, where they have a mobile eye clinic in going to northern communities. We hear of mobile libraries that they used to go around to communities before they had internet and e-books. So I'm wondering if maybe that's one solution that I'm going to throw out there, is maybe we need mobile access centres that could move around and provide supervision in different locations and be more accessible, because that's why it's called access centres. It's supposed to be accessible. I just want to mention the Ontario Indigenous Children and Youth Strategy, which is a big part of the discussion of this legislation, Mr. Speaker. We're repealing the terms Indian and Native, and we're replacing them with First Nations, Inuk, or Métis child, and, of course, First Nations, Inuk, and Métis children and families. And they want to improve the reporting about services provided to our Indigenous people. We know we have a very unique relationship here in Ontario, and I think that there's talk of having more agencies and more training in the Indigenous communities themselves to manage their child welfare concerns. And we have to consider all the impacts on those communities, those children, and those families. And Jordan's principle is about Jordan River Anderson, who was an Indigenous child who died in the hospital, born with multiple medical problems, and the reason he had to die in hospital and not go home and receive home care, he did have a home to go to, is because apparently the governments in 2005 were arguing over who should pay for his at-home care. So that's a tragedy, and that's been a focus of this piece of legislation as well as others. How do we ensure that we streamline things and have things more efficient and do what's in the best interest of the child, not necessarily fighting between different ministries and different agencies in exactly the same province? I want to summarize a bit by saying that the PC caucus and I intend to support Bill 89, but we're looking forward to proposing some amendments in the committee and hearing all of the input from the communities. And Bill 89 will, of course, increase that age of protection to include 16 and 17-year-olds, and we're hoping we will see some good data collection and better accountability and effectiveness of service, revise the rules around adoption and licensing of children's residences. We feel confident that Bill 89 will not prevent any parent from adopting or maintaining custody of a child so long as those parents provide or can provide the care, the support, the safety that the child deserves. This bill comes after many organizations and stakeholders have shown that the current system is failing many of Ontario's children. It also marks the potential to replace the 32-year-old piece of legislation, and ongoing problems still mean that children often slip through the cracks. Now, to be fair, Mr. Speaker, we don't hear about all the good stories, and there's tens of thousands of them. There's fantastic foster parents. The care workers, as I've said, are working very hard, and unfortunately, those don't make it into the newspaper headlines. And we want to see more clarification about when the ministry can remove Children's Aid Society board members, appoint supervisors to take over societies, and even force amalgamation of societies. We all know a clear process will give both the agencies and the families some clarity on how they can expect to follow through. And if you have a concern with the Child Protection Agency, what are the exact steps that you should be taking before the ministry would even take over? We're particularly supportive of increasing the age, and we think it will go a long way to fighting human trafficking, the age in care, of course, to 18. But again, we have to ask, where is the money going to come from? We understand that children, this is what I was told by the ministry staff, children won't be forced to go into care to the extent they are before 16. They'll be given the option to not go into care but still have monetary support by the province. And so I think that when they told me that, they're kind of hoping that not that many children who are 16 and 17 will want to go into care. And I would suggest that I think that a lot of children will want to go into care if they hear that that's the standard. Children and youth tend to often do what their peers are doing, and if they hear that most 17-year-olds who don't have a home are going into the care system, then they will be more willing to go into the care system. So it might take a while till we get the numbers up. And I want to mention my colleague, the member for Haliburton Kawartha Lakes Brock, who works so tirelessly to prevent our vulnerable youth from becoming victims in this skyrocketing trade of humans for sex, and it really is a modern-day form of slavery. My PC caucus colleagues and I will do our best to ensure that this legislation protects children and ensure they are provided with the services they deserve. And I just want to mention a couple of things, which is I was taught by my late mother that there's no bad kids, and we won't say there's no parents who aren't adequate for taking care of children. But a lot of times it's just a bad match. And it's just not the right child for the right parent. And I spent a lot of time, and I still do, with many people, teenagers in my community, because they want to volunteer for community service hours or they're interested in politics. And their parents are always like, you spend days with my child. How can you stand them? They're so sarcastic, they're so rude, they're so grumpy. And I just always feel that maybe we need to have a program in place where we trade each other's teenagers, because I find everybody's teenagers wonderful. Mine can be grumpy sometimes. But it is an interesting scenario sometimes. and to do better education, I would point out, of our own children in the school system, not just parenting classes or home economic classes or things like that, but to really have those discussions with kids about anger management, that there may be a time in your life where you experience anger that you're just literally seeing red, and to count to 10 and to learn how to deal with that. So I'm going to pass the rest of my time to my colleague, the member from Dufferin-Caledon. I look forward to hearing what she has to say, and I would remind everybody that it takes a village to raise a child. Thank you, Mr. Speaker.
Thank you.